Well, to discuss this further, I'm joined from Claremont, California by Catherine Lombardo. She is an attorney representing some of the victims of the Las Vegas shooting. In Washington, we have Henry Sue. He's a partner at the Constantine Cannon law firm, which specializes in commercial litigation. And from Denver, Colorado, Thomas Russell. He is a law professor at Sturm College of Law at the University of Denver. Thanks all three so much for joining us. Thomas Russell, let me start with you. I mean, suing the victims, I know it sounds horrible, but do you think MGM could have found a legitimate approach to actually protection from litigation here?
I think this is a bit of a ham-fisted effort by MGM. The goal that they've described is to consolidate the suits in one courtroom, and that's something that they could accomplish through other mechanisms. In a letter that the CEO, Jim Murren, sent 4 days ago to employees, he says that was their only goal. But of course, other goals include shifting responsibility to the vendor of security services, reducing the total amount of damages that people can complain about, and also eliminating them. So I think there are certainly other ways. Multi-district litigation would be one possibility that MGM might have accomplished the goal that they allege is there. I might say, though, one of the things about MGM is that in this litigation, I do regard them as one of the victims as well, and I think that that is something that perhaps we should keep in mind.
As one of the victims, I mean, so having said that, why couldn't they just use the post-9/11 law they're proposing as part of their defense instead of making themselves the plaintiff in this case?
I think they could have, and I think legally they should have, and certainly from a public relations standpoint, they should have done that. I mean, it's to be hit with a lawsuit or served with a suit, if they've indeed gone out and served people, is a pretty frightening thing. So this sort of preemptive shot across the bow does strike me as a little bit unusual. They might have just waited, pushed to consolidate suits together, and then also push them into one particular federal court. That would have been a better approach, probably. On the other hand, being a plaintiff in personal injury litigation is extremely difficult emotionally, and all of the plaintiffs can expect that their medical histories and their emotional histories will be gone through with fine-tooth combs. So to the extent that this is a horrible thing, it's just one of many horrible things that plaintiffs in personal injury litigation face.
Henry Sue, let me ask you, I mean, people could argue this is kind of a novel approach, but you think it does very serious damage, as Thomas actually agrees, to the hotel's reputation. What are the costs for MGM there?
Well, I just think that, you know, for a company that's in the hospitality entertainment industries, you know, so much of its business depends on word of mouth and goodwill. And when you're suing as many people as MGM has, you have to expect that there will be a lot of social media traffic, you know, much of it negative to the company for months to come, for as long as the litigation is going on, and that this will continue to be picked up in the news. So it isn't simply a crisis that, you know, blows over and, you know, turns quiet. It's going to be something that's going to be of continuing interest to the public.
Then let me get your opinion on why you think a lawyer would choose this path.
Well, I have to obviously, you know, give some credit to the lawyers for MGM. They've thought about this, and as the professor has said, you know, one of their stated interests here is in trying to consolidate and manage what could be potentially, you know, hundreds of lawsuits around the country and in various state courts around the country. And what they're trying to do is to use this federal statute to get the matter into federal court, where the rules and procedures are much more, you know, uniform, and they can expect, you know, to have a way for the federal courts to coordinate this type of case.
Okay, let me get to Catherine. Catherine, I'd like to get first your response as to what Thomas had to say about the hotel actually being a victim in this case as well. Why are you suing the hotel on behalf of the clients you're representing?
Well, I think that that's an untrue statement, and it couldn't be further from the truth. My clients and the 22,000 victims who were attending the Route 91 Harvest Festival country concert on October 1st of 2017 were innocent victims. This could have been prevented. We know more now than we ever did, and we know how strongly now that what we've been saying all along is true and will be proven in a court of law, that this could have been prevented. The shooter spent many days in that hotel room up on the 32nd floor. He brought his arsenal of weapons and ammunition and power tools and supplies up to the 32nd floor over a 3 or 4 day period, perhaps even a 5-day period.
But Catherine, let me cut to the chase there. What did Mandalay Bay Hotel fail to do in this case that all the other hotels would have done that make Mandalay Bay personally responsible here? No other hotel had these security mechanisms in place.
They would have caught it. You see, ever since 9/11, there has been training provided to all of the casinos and the hotels in Las Vegas, because Las Vegas is at the top of the list for a potential terrorist attack. And so the Department of Homeland Security and the department named before that was created have been training all of the security companies throughout Las Vegas and the hotels, providing them with active shooter training, terrorist attack training. This training included training on how to identify a potential threat. There are indicators of when a person could be a threat, could potentially be an active shooter, just like this shooter was, this murderer was. They missed it. Not only did they miss it, they turned a blind eye, because this shooter was a high roller in the casinos. He'd been there many times. They knew him. He brought in all of this heavy equipment, weapons, guns, ammunition, and he tipped the bellhops, the valet guys. They carried in his weapons for him. They removed them from his car, put it on a cart, walked through the casino, took it into the back service elevator, up to the 32nd floor, brought it to his room, and unloaded it for him, where he spent the next couple of days setting up his trajectory, preparing, planning. They never went into his room to clean it. At some point, a maid did go in, but he hadn't had his arsenals out. He was hiding them. But you see, they could have and should have noticed this. Now, MGM has been saying that this was a first time this has ever happened, that this was unforeseeable. They're wrong. Not only was it foreseeable, but it was foreseen, because they were preparing for this. They should have prepared for this. And just 3 years prior to this shooting, the exact same thing was about to take place. Another active shooter had gone up to the higher floors and set up his rifles and his arsenal pointed at the Las Vegas Strip, ready to shoot innocent victims walking down the Strip. A maid had come in and she saw it. She called the police and the FBI. That person was criminally prosecuted. MGM has made that hush-hush. Not only did they make it hush-hush, but in the court filing, they told the judge that nothing like this had ever happened before.
Catherine, I'd like to get back to Thomas here then, because Thomas, you had said that the hotel, in a sense, was also a victim. Now, hearing how strong of a case Catherine has put forward, you would have to expect MGM to look for very novel ways of trying to fight this, because it sounds very clear from what Catherine is setting forth that MGM doesn't have a chance in not being proven somewhat liable for this massacre.
That's right. That's right.
Well, I mean, judges and juries decide about facts, so the challenge for the plaintiff's attorney here is to establish that the hotel acted unreasonably, and I absolutely agree that the evidence that we've just heard there is compelling. when I say that MGM is a victim as well, one of the things that we do in tort litigation is we sort of balance the relative causation of the various parties. So the question is going to be, to what extent is the shooter responsible for this? To what extent is the hotel responsible for this? To what extent is the security company that provided security down on the ground? To what extent does that liability split between different entities of MGM? So that's the simple point, and that of course having a shooter in your hotel, damages the reputation, and then MGM further damages their reputation with how they're handling this litigation. So, I think the plaintiffs will bring forth that evidence. And again, in the face of that, this invocation of the Safety Act tries to eliminate elements of the harm that the clients have suffered here, that the injured people have suffered, and tries to shift that literally downstream or down on the ground to the insurance company that insured the company that provided security services or took tickets or whatever they did on the ground. It's a little unclear from MGM's filing.
Okay, Catherine, go ahead, and then let me get to Henry.
It's reprehensible what MGM has done by suing my clients and the victims. I expect that they're going to sue in every single state in the United States. And it's wrong, it's reprehensible, it's also unprecedented. And it's a case that's never been tried before, the Safety Act invocation, and it's wrong. The Safety Act does not apply to this scenario and this particular shooting. The Safety Act was not designed for this scenario and this shooting. The Safety Act authors did not have this in mind. You see, MGM is trying to say, we can't be sued, Judge, and we want you to make a ruling that says we just can't be sued. We are not liable at all for any of the victims in any way whatsoever. That's exactly what they wrote in their court filings to the judge. They're putting the blame on a yellow T-shirt security company that was hired to, like he says, take tickets and kind of manage the crowd. This yellow T-shirt security company had nothing to do with MGM's security and allowing the shooter, Stephen Paddock, to wreak havoc and murder and shoot at 22,000 people. That's all on Mandalay Bay and MGM. They cannot shift the blame.
Okay, let me point that to Henry then, because that is a major part of MGM's case here, in that they say they hired a security company that had been vetted by Homeland Security, and that it was their job to ensure the safety of those thousands of people at this venue. Do you think there's any legitimacy to that?
Well, I think it goes, to the facts that Catherine has recounted, and to Thomas's comments about, the jury and the judge figuring out, how to apportion the responsibility here. I would say that, yes, MGM may have hired a security company to handle the security on the grounds on the night of the concert, but the question is, what did they do in the days before, and what steps could they have taken, as Catherine has suggested, to identify Mr. Paddock as a potential threat? So that's one question. I would also note, Thomas was talking about liability, and one of the concepts in tort law is what we call proximate cause. In other words, figuring out what action or what omission was the root cause of this incident, and the Safety Act has that requirement of proximate cause. That is, it says that the seller of the technology, in this case the security company, is liable only if it was the proximate cause of the incident.
Okay.
And so just because you can sue the security company doesn't mean necessarily that MGM isn't also jointly responsible, or even more responsible if there was an opportunity, for instance, to identify the shooter in the days before the concert.
Thomas, go ahead quickly. I saw you had a response, and then I need to ask Catherine something else. Go ahead, Thomas.
Just quickly, I agree with I agree with Mr. Sue's point there, and analytically, I conceive of it as an event on the ground and then also a hotel. And although I know MGM owns all of those entities, even if the Safety Act provided some kind of narrowing of damages for the events on the ground, it's not clear to me why it should insulate the MGM's actions in Mandalay Hotel at all from scrutiny. So I think that in that way, the filing that I read didn't make any sense.
Okay, Catherine, let me ask you. I mean, we're focusing on the responsibility of the hotel here, but actually your case is going after other parties involved. And from the outside, I mean, remember, we're catering to an international audience here as well. They look at this and say, this is an American problem specific to the United States, whereby gun manufacturers, those bump stocks manufacturers as well, are really the ones that should be held responsible for producing weapons that are meant to kill absurd numbers of people at a time. Why is it that a hotel has to assume responsibility and not more is put on the gun manufacturers and those who made the weapons that killed these dozens of innocents?
Well, because that's the law here. And we are not suing the manufacturers of the guns or the bump stocks. They are not included defendants. In fact, they are, for the most part, immune from liability and from being sued. And that's just the law. The law of negligence is well established. It's been tested and tried and reasserted for decades after decades of judicial scrutiny. The law of negligence is what rules here. And here in America, in the United States, in Nevada, in California, that law is what allows the victims to file a lawsuit, because when you are a guest in a hotel, you are expected to be protected by that hotel. And here, the MGM Mandalay Bay, which is owned by MGM, they failed to protect these 22,000 people who paid money. Now, keep in mind that the concert venue, the pavement where they were standing in the concert underneath the hotel, was owned by Mandalay Bay and MGM. In fact, the entire event, the permit that was taken out from the city and the county was taken out and applied for and signed by MGM executives. And they know it.
But we are aware that there are victims that are actually suing the bump stocks manufacturers, because that...
Not anymore. No.
Has that been dropped?
Yes, I believe so. There were a few lawsuits originally throughout the country, but that has been dropped. We've all of the lawyers throughout the country have all joined together. We are a united force. We are a united front. In fact, just 5 days ago, we had a very, very huge meeting in Las Vegas together. We are all on the same page and presenting a very, very strong, united prosecution against MGM, which, by the way, if I can state, I think it was Thomas who talked about why MGM filed this was to try to coordinate or consolidate all of the lawsuits. No, that's not necessary. We are already coordinated and consolidated, and the judge will know that in just a few days. So there is no need for that. They're doing this. It's a ploy. It's a tactic. It's a dirty trick. And it's a PR nightmare for MGM. I can't believe they did this. I don't know who made the decision to do this.
We'll see how this unfolds in court. Thomas, very unfortunately, I can't give you a final word. I know you had a comment there, but we are completely out of time for this segment of the Newsmakers. I'd like to thank all three of you so much for joining us.